Hello, welcome to Lobus. Today we'll see natural justice principle. What is natural justice? Its origin, meaning, and its landmark cases. Its landmark cases play an important role wherever you present your things, or in your where you write your exams, or when you're going for your any presentations, or in your cases. What all things these landmark cases will be very helpful, and you have to mention such landmark cases in your future things. You have to know this where this landmark cases applies. So, but in my college days also, my teachers were very specific about this, that for a topic with this case is very important. You need to put this case there. You have to write this case so that you can grab more marks. That case, when you mention the case itself, the exam who is correcting your marks, or who is listening to you for any presentations or any sort of thing, they will have a good idea or fair thing that okay, the person knows about the topic and the case related to it. So it is very important that you know some of the topics in which these landmark cases come. So we'll see the landmark cases also, and please stay with me, and please do like and share and subscribe to my channel if you like my videos. Okay, so that you get the notifications when I put a new video. Okay, so let's start with the natural justice principle. So natural justice, as you know, it's a very important topic in administrative law. We'll move on to the topic. Okay, so natural justice, what is that? It is a fundamental legal concept that ensures fairness, transparency, and consistency in legal and administrative proceedings. Okay, so this is a concept which is ensuring fairness and transparency and consistency. What is in what all things in legal and administrative proceedings. Okay, this is natural justice, and it is based on the idea that individuals should have a right to be heard, and decisions affecting their right should not be arbitrary. That is, it should not affect individuals' rights or ideas. That is, that they have they should be given the opportunity to be heard, and it should not be taken arbitrary. The decisions by the court which is taken should not be arbitrary. It has to have a fair proceedings, and it should be heard properly. Okay, so this is natural justice. So what it means that the sense of just and unjust. It simply means the sense of just and unjust. Okay, so we move on. So natural justice refers to the inherent legal principles ensuring fairness in the decision making process. So as we seen in the earlier thing, it is the inherent legal principles which ensures fairness in the decisions making process. The decisions taken by the court should be fair, just, and reasonable, as you have seen. Okay, so it has two rules. The main rules for natural justice is there are two maxims to that. That is, one is Nemo debet esse juris proprietà causa and Audi Alteram Partem. Okay, these are the two main rules for the natural justice. And what does this mean is that no one should be a judge in his own cause. This is done to prevent bias. So, if I am a judge in my own case, I will make it biased, right? So it should not be that. To prevent the bias, this is the principle which is used. No one should be the judge of his own cause. Then the second one is that Audi Alteram Partem. That is, both parties should have an equal opportunity to present their case, or it's here the other side. This Audi Alteram Partem I have discussed earlier. You can go and check it. Okay, in my videos. This is a detailed video in Audi Alteram Partem. is one of the important principles in natural justice. Okay, so you can have a look at the video also. So these are the two main rules which is followed. Nemo debit esse Judex proprietà Causa and Audi Alteram Partem. So when you write your exams and all, no, please to mention these rules and very important rules which is there in natural justice, and it has to be mentioned. Okay, so we move on. So the principle of natural justice, where it is derived from the word just natural. Just natural is the word from which it is derived. It's the law of nature. This is from the Roman law. It is derived from the Roman law, which means law of the nature. Okay, it is closely related to common law and moral principle. So it describes, natural justice describes what is right and what is wrong. And okay, so this is distinction. It is a difference between, it describes a difference between what is right and what is wrong. So there we have a clarity on what is right and what is wrong. And natural justice, it is the set of procedural rights and principles. Okay, it is a procedural rights. Remember, it is not any other right, it is a procedural rights. Natural justice has many shapes, shades and colors. It is modified and it is a law of the nature. It is applied in a just natural way, and it is considered with other, here the other side, as you have heard, right? So it is neither fixed nor codified. So in natural justice we cannot say this has to be like this has to be like this. It is not so. It is not fixed, is not codified. It is like it should be the decisions which is taken, it should be fair, just and reasonable, and there should not be any kind of bias or all sort of things. These are things which is considered in natural justice. So it's not fixed. Okay. It is a law of nature which is not derived from any statute or constitution. Okay. You hope you understood. There is no statute for this natural justice, or any nothing is written in any constitutions. It is derived from the nature, the law of the nature. Okay, so it is also called natural justice is also called as universal justice or substantial justice. This is one name, universal justice or substantial justice, or it's also called fundamental justice or fair play in action. Natural justice is also called in this name also. Okay, it is not judge-made law since it is recognized from the earliest times. So you have seen it's not a judge-made law. So what natural justice simply means to make a sensible and reasonable decisions making procedure on the particular issue. Okay, so this is a simple meaning of natural justice. This should be very sensible decision must be taken when there is the procedures followed. There should be fair and reasonable things should be taken by the court. So the principle, the natural justice principle is intended to, what the main intention of natural justice principle is that invests law with fairness. Okay, you have seen that. So the natural justice principle is intended to invest law with fairness, to secure justice and to prevent miscarriage of justice. This is a very important thing which you might be hearing. Okay, you have to be very well versed with this to prevent miscarriage of justice. This is a very important part of natural justice. Okay. So the principles of natural justice have been adopted and followed by the judiciary to protect public rights against the arbitrary decisions by the administrative authority. So, to prevent arbitrary decisions of administrative authority, this natural justice principle is adopted, okay, by the judiciary. So, the main motive what is that? To prevent miscarriage of justice. So, we move on to the case laws. This is a very important case in English law. This is an English case, and this is called the Magna Carta of natural justice. This is a case, Magna Carta case in natural justice. This is Rich versus Bradford. Okay. So we'll see the facts. What is that? So Ridge was a chief constable in Britain and he was dismissed from his positions without giving any opportunity to be heard. And he was not given any opportunity to defend his side, or they didn't allow him to say what he has to say. Okay, so he was dismissed after being charged with corruption and later acquitted. So this was a charge against him. He was charged for corruption. Ridge had been denied a chance to present his case before the committee made its decision to dismiss him. So the committee made a decision and dismissed him without giving an opportunity to Ridge to defend his side, what he has to say. Then here he was not given an opportunity of hearing by the Britain Watch Committee. Straight away he was dismissed, saying he has done corruption. So the watch committee, which had the power to dismiss him, took the decision without following the rule of natural justice. Specifically, which was not given an opportunity to hear the charges against him or know the reasons for the dismissal. So this was the scenario. Okay. So the House of Lords held that the dismissal of the Chief Constable Ridge was invalid because it violated the principle of natural justice. Specifically, Ridge was denied the right to fair hearing and fundamental component of procedural fairness. So the House of Lords held while deciding the case what they dismiss the held that dismissal of the chief constable was invalid, and because he was not given opportunity to hear, and this is not the natural justice principle was not followed, there was no fair hearing, so this dismissal was not valid as per the House of Lords. So the case, the administrative authority or in any authority, what the decisions which they make should be fair and transparent, and it should be just, and all the natural justice principle must be followed by deciding a case. And when a person is charged with a anything, that person has to be given an opportunity to defend himself, or the charges which is provided against him must be said to him so that he will know what is the charge against him, what are the things against him. So this is a very important case in administrative law, in natural justice. And the next case is A.K. Kripak versus Union of India. This is an Indian case. That was an English case. This is an Indian case. This is an important case in India, Indian case for natural justice. So this case, A.K. Kripak versus Union of India, is a landmark decision in administrative law. Okay, particularly in context of procedural fairness and right to fair hearing. So while taking up this case, this is a case on procedural fairness and right to fair hearing. This is the thing which is the main thing of this case, procedural fairness and right to a fair hearing. Okay, this is the topic which is covered in A.K. Kripak versus Union of India. So we'll see the facts. So what is the facts? Was state of Jammu and Kashmir. The selection was done for Indian Forest Services, and the person who was a candidate, Nashing Baum, was a candidate himself, and he was also in the selection board. So what there is some sort of bias, right? It should not be that the candidate person is a candidate and he is also in a selection board. So it will not be a proper interview. He did not attend this interview and he did not present himself. While he took the interview, but he did not appear himself. So, but when the selection was done by the PSC, he was selected for the position for the Indian Forest Service. So, what happened? The other candidates they filed a writ petition saying that the order of selection is not proper and nothing bound the natural justice was violated. So, what the court observed, the court found that Nashing-Bond dual rule presented a conflict of interest, leading to potential bias in the selection process. See, as I mentioned, so he was playing a dual role. He was also a candidate. He is also in the selection board, which is not permitted, which is not allowed in any sort of law, right? So when you are going for an interview, you are a candidate and you are also in the selection board means the decisions will not be proper. There will not be fair decisions, right? There will occur any sort of bias with selection board. So additionally, the absence of examinations or interviews in determining candidate suitability raised concern about the procedural fairness. Again, he was not present for the examinations as well as for the interview. It was not a proper selection by the PSC. So this was taken up by the court and the court found out that the court quashed the contents notification, holding that selection process violated the principle of natural justice by allowing a prospective candidate to be part of the deciding body, thereby undermining impartiality and fairness of his participation in the deliberations of selection board. There was a conflict between his interest and duty. So the Supreme Court found that there was a conflict between his interest and duty. So his interest was he was he wants to go for this for service, but his duty, he was also a candidate and he was in the selection board, which is a dual action. Dual thing will not be permitted, and his interest and duty conflicted the selection procedures, and it was biased also. So the selection process was caught by the Supreme Court of India, and the selection process violated the principle of natural justice. This is what the court held, and the person was not given the position. Okay, so this is A.K. Kripak versus Union of India. So another case is that Menaka Gandhi versus Union of India. This case is also called passport case. Okay, Menaka Gandhi's case is also called as a passport case. A very important case in Article 21 also, and you'll see in Article 14 also. So we'll see here in natural justice also. You can apply this. What is that? The Supreme Court ruled that the principle of natural justice are a part of the constitutional framework under Article 21, right to life and personal liberty. The court held that the procedure established by law must be fair, just, and reasonable. In this case, denial of the right to be heard before impounding Menaka Gandhi's passport violated natural justice. While the passport was impounded, Menaka Gandhi was not given an opportunity to defend herself. So it amounted to violation of natural justice. This is another case in natural justice. So now this case can be applied in many situations also. Okay, 14, 19, 21, all these cases. You can apply this case. Okay, so these are the three principle of natural justice. What are they? Let the other side be heard as well. That is Audi Alteram Partem. This is Audi Alteram Partem. Okay, that is here the other side. This is the one of the principle of natural justice. And the next principle is no one is a judge in his own cause. This is doctrine of bias. Doctrine of bias. This is the second one. And provide reason for decision. This is the third one. Okay, reason decision. So this topic we will be covering in our next video. These are the principles of natural justice. Okay, we'll see one by one. Audi Alteram Partem is already covered. You can just refer to that video. The next two will cover in our next videos. Natural justice. Hope you understood what is natural justice, meaning, origin, and the landmark cases. Okay, so see you in our next video. Bye bye.